All right, we're going to turn now to Wisconsin for a plea hearing for a mother accused of driving drunk and then flipping her vehicle with her 2 young children in the back seat. It happened back in November of last year. According to court records, Megan Oster-Schultz hit 2 parked cars and flipped her Jeep with her 6- and 8-year-old children and her boyfriend inside the car. Now, the children were unharmed, thankfully. Police say Schultz smelled like alcohol and a pink water bottle was found on the driver's side of the vehicle. And that water bottle didn't contain water, it contained alcohol. The former champion figure skater was charged with 1 misdemeanor count of operating while intoxicated with minor children under 16 years old and 1 count of failure to provide a blood/breath sample. So let's go inside the courtroom now for the beginning of that hearing.
24 TR 8100 and 24 CT 786, State of Wisconsin versus Schultz. I'll take appearances, please.
Jeff Roll for the state. And good afternoon, Your Honor. Megan Schultz appears with counsel. Frank J. Parise, also present in court, are her parents.
Good afternoon. State compliant with victim rights?
We are, Your Honor. It's a victim impact statement under court.
Thank you. All right, this is here again for a plea and sentencing. Are we ready to proceed this time?
Judge, yes, I would indicate that pursuant to the agreement, Ms. Schultz will be pleading guilty to the single count in the complaint. At the time of sentencing, the state will be making no specific recommendation as applies to the jail time. However, they will be recommending, and I don't have it in front of me, but it's in the plea form. I think it's $1,000-something fine, and
it's $1,019.50. That
yes.
Sound right?
Yes.
All right.
And then the revocation period, and then also dismissing the TR.
Is that your understanding, Ms. Schultz?
Yes.
All right. I know we did this before, but I have a series of questions to ask you. If at any time you can't understand me, have questions of your own, or can't hear me, please interrupt me and let me know, all right?
Okay.
All right, thank you. You're 36 years old and have more than 12 years of schooling, is that correct?
Yes.
Fair to say you read and write the English language pretty well?
Yes.
Did you review the plea questionnaire waiver of rights with your attorney and fully understand it?
Yes.
Is the information in it true and accurate to the best of your knowledge?
Yes.
Did you also go over the elements for operating while intoxicated with minors in the vehicle?
Yes.
All right. Plea questionnaire indicates you wish to change your plea to that of guilty to that charge. Is that your understanding?
Yes.
Do you understand that if the court accepts a guilty plea from you, you will be found guilty?
Yes.
Do you understand that a guilty plea waives all non-jurisdictional defects and defenses, including constitutional claims?
Yes.
Do you understand you're giving up your right to a trial in this matter?
Yes.
Do you understand that by entering a plea here today, you're waiving your right to remain silent and to testifying on your own behalf?
Yes.
Do you understand that the state has the burden of proving each and every element of the charges in the complaint?
Yes.
Do you understand that that burden is beyond a reasonable doubt, which is the highest burden in our court system?
Yes.
Do you understand the elements that the state must prove are that you drove or operated a motor vehicle on a highway and that you were under the influence of an intoxicant at the time that you drove or operated that vehicle?
Yes.
And that there was minor passengers under the age of 16 in that vehicle?
Yes.
All right. And while there may or may not be a recommendation promised here by the state, this court is not bound to follow any recommendation made by any party and can sentence you up to the maximum penalties in the complaint. Do you understand that?
Yes.
Do you understand the penalties are a fine of $350 to $1,100 and imprisonment of not less than 5 days nor more than 6 months?
Yes.
Has anyone made any threats or forced you to enter a plea here today?
No.
Has anyone made any promises to you in order to get you to change your plea here today other than the agreement as stated on the record?
No.
Has anyone, are you entering a plea change freely, voluntarily, and knowingly?
Yes.
Have you used any drugs or alcohol in the last 24 hours?
No.
Do you understand, did you review the complaint in this case?
Yes.
Do you understand what it alleges you did?
Yes.
Do you agree that the facts contained in the complaint are accurate and may be used by this court as a basis of fact to accept your plea here today?
Yes.
Do you understand that if you are not a citizen of the United States, you are advised that a plea of guilty for the offense for which you are charged may result in deportation, the exclusion from admission to this country, or the denial of naturalization under federal law?
Yes.
Are you satisfied with the legal representation that your attorney has provided you in this matter?
Yes.
Has he answered all your questions?
Yes.
Are you at all confused about what you intend to do here today before this court?
No.
Attorney Parise, have you had sufficient time to go over the plea questionnaire and waiver of rights with your client?
All right, so things get a little emotional there, realizing what she did, now having to plead guilty. Let's bring in our guest this hour, still with us, former attorney, prosecutor, and prosecutor Randolph Rice. Attorney and former prosecutor Randolph Rice is what I meant to say. Randolph, you know, it's interesting, as a former prosecutor, you know this. You know, we watch trials all the time. That's what we do here at Court TV. But that's really the tiny percentage of what happens in the system. What we're seeing happening right now is really the bread and butter. This is what happens in the system every single day. Tell us a little about it and a prosecutor's approach to a case like this, because it's a misdemeanor, but still very, very serious.
Extremely serious, Michael, and you're right, because this is something that happens every single day. When I was a prosecutor, you know, if I would have had 60 cases on the docket, I bet 58 of them probably resolved themselves exactly the way this case is resolving itself. And typically the best way for a prosecutor to actually get to this point is having a great case. The police officer's doing an incredible investigation, providing a good case to you, and then presenting it to the defense attorney so that a plea does happen.
Now, this is one of those cases where didn't require a tremendous amount of footwork. It was all sort of right there in front. The thing that really shocked me in this case is the decision with the children in the car to drive. Obviously, something bad happens, but then my understanding is there was this pink water bottle that she was actually drinking in the car while driving drunk. And it shocks me, Randolph, that this case was charged as a misdemeanor. I looked at Wisconsin law. There was some opportunities for something more. She was, in fact, a first-time offender. Talk to me about the charging decision here, and if there was something more here to send a broader message.
Yeah. You're right. I mean, a lot of times in these cases, the police officers are going to make the initial decisions about what to charge, and obviously the prosecutors can come in and maybe add additional charges onto this. It may have been that her lawyer got ahead of that, and sometimes defense attorneys can say, hey, look, we think we may be able to resolve this with a plea. Don't overcharge it so that we can resolve this case with a plea. But you're right. You know, having a water bottle full of alcohol at the scene while flipping a car with your kids in the back is not good facts.
Yeah, not at all. All right, Randolph, stand by. We got a lot more to come, but we're going to take a break. But before we do, I have an update in our other live trial, the caught in the crossfire murder trial of Parise Larry. Now, he faces life in prison if convicted of shooting and killing 20-year-old Tatiana Zek while she was just taking out the trash at her apartment back in May of 2023. Now, he was just 14 years old at the time of the shooting. Today, Larry's now 19-year-old co-defendant, Antonio Johnston, he took the stand to testify for the state as part of a deal. Now, he pleaded guilty to all charges in exchange for his truthful testimony. He hasn't been sentenced yet, so he's hoping for some considerations there. Today, he testified he had no intent to kill Tatiana and that his intended target was another teen, Keyshawn Johnson.
Are you familiar with someone named Tatiana Zek? And how do you know Tatiana?
Personally, I just know her through the tragedy that occurred.
And did you have any intent to kill Tatiana Zek on May 7th, 2023?
No.
And did you have any intent to harm Tatiana Zek on May 7th, 2023?
No.
And when you fired your gun, did you have an intent to harm Keyshawn Johnson? And when you fired your gun, did you have an intent to harm anyone other than Keyshawn Johnson?
No.
Just Keyshawn Johnson?
Yes.
How did you feel when you learned what happened to Tatiana Zek?
I was devastated.
He would go on to say that he saw the defendant with a gun and actually saw him shooting the gun in the direction of Keyshawn and Tatiana. All right, we'll continue to bring you updates on that trial throughout the week. Coming up on Court TV, we hear from the prosecutor and defense attorney in the plea hearing of Megan Schultz. She is again charged with OWI, operating while intoxicated, after flipping her Jeep with her 2 children in the car while allegedly driving drunk. That hearing continues next. Welcome Welcome back to Court TV Live. I'm Michael Ayala, back now to Wisconsin for the plea hearing of Megan Oster-Schultz, the mother of two and former champion figure skater who was charged with OWI back in November after police say that she hit two parked cars, flipping her Jeep with her young kids and boyfriend in the vehicle at the time, all the while driving drunk. All occupants were unharmed, thankfully, but police say that Schultz refused to participate in a standardized field sobriety test. An officer reported smelling alcohol coming from her breath and she was unsteady while walking to the squad car. And based on the officer's observations, Schultz was arrested for operating while intoxicated and failure to provide a blood or breath sample. All right, let's get back inside that courtroom now.
What do you intend to do here today before this court?
No.
Attorney Priest, have you had sufficient time to go over the plea questionnaire and waiver of rights with your client?
Yes, Judge.
Have you gone over the discovery, the allegations of the petition, and the potential defenses available to your client?
I have.
Are you satisfied that your client understands the charges against her, the elements thereof, and the possible consequences of an adjudication of guilt?
Yes.
Have you gone over her constitutional rights and the effect of waiving those rights here today?
Yes.
Are you satisfied and of the opinion that your client is freely, knowingly, intelligently, and voluntarily entering into a change of plea?
Yes.
And do you believe the facts from the criminal complaint set forth an ample factual basis for this court to accept a plea from your client to the charge of OWI first offense with minor in the vehicle?
Yes.
All right. Ms. Schultz, the complaint alleges in count 1 that on November 17th, 2024, in the city of Kenosha, Kenosha County, Wisconsin, you did operate a motor vehicle while under the influence of an intoxicant and committed this offense with minor children and under the age of 16 as passengers in the vehicle, contrary to Wisconsin state law. How do you plead?
Guilty.
Thank you. All right. I've reviewed the contents of the court file and find there is a factual basis for the plea. Court does accept the plea from the defendant, finds her guilty, and orders that a judgment of conviction be entered consistent with count 1 in the complaint. Court is satisfied the defendant has freely, knowingly, intelligently, and voluntarily entered into their plea of guilty, and the court will accept that plea. As to sentencing, state.
Thank you, Your Honor. Per the recommendation and the agreement of the parties, state's recommending jail but staying silent on the amount and defer to the court's discretion. However, we will be requesting a 12-month IID order, 12-month driver's license revocation, and a $1,019.50 fine. There's just a few things that the state would want the court to keep in mind here in proceeding to sentencing today. I will, of course, note the defendant has no prior record. I don't think there's any allegations thereof of that. And I know that the victim in this case had filed a victim impact statement with the court talking about restitution that had not been paid. Since that has been filed, I understand that the defendant has made payments restitution and provided that in its entirety, just so the court was aware of that. Otherwise, I would just like to have the court review and understand some of the allegations in the probable cause statement, including that the defendant tipped over her vehicle while driving intoxicated. VAC came back in this case for an amount of .218, and she had been driving the vehicle with her two minor children in the car, including a 6-year-old and an 8-year-old, before crashing into a parked car on the side of the road. I understand that the children were checked out by Kenosha Fire Department and they were deemed fine on scene. No injuries were suffered. However, driving with a .218 blood alcohol content with two children in the car and then the crash resulting in the vehicle tipping over, it is miraculous that nobody actually was hurt. And I think the victim impact statement is accurate to note that it was only by grace of God that this didn't turn out any worse than it did. It could have been a car coming from oncoming traffic, but in this case, the defendant did strike a parked car. Otherwise, I would just note that while the defendant was forthright about the number of drinks that she had consumed when talking to officers, I would note that eventually the defendant stopped answering questions and did refuse a PBT understand at the time. Otherwise, I have nothing further to add and defer to the court. Thank you.
All right, Attorney Priest.
Judge, thank you. I would note that Ms. Oster is age 36. She is a lifelong resident of Kenosha. Her parents are present, and honestly, she comes from great stock in that sense. I've known her parents probably since high school, maybe even longer, and they are, as they the axiom is pillars of the community. Ms. Oster herself does have and continues to have a career in figure skating. She coaches, she coaches young people and is very highly thought of, as you can read from the letters. They think very highly of her, are not making excuses for her behavior here, but understand and believe that she is committed to better herself and to be accountable for her actions, which also explains her guilty plea here today. I would note, Judge, she has absolutely no prior incidences of anything, including alcohol-related or any other incidences of any kind in her 36 years. I would note, too, Judge, that the damages that were talked about, we actually were requested very early on. The police report was incorrect when it said she had no insurance. She was fully insured. And in fact, when we were notified that there might be a problem from the DA's office, we immediately...
All right, so we're going to bring you those final moments from the Megan Schultz hearing right after the break. She faces up to 6 months in prison. We'll see what the judge does. But before we do go to break, I want to turn to Ohio quickly, where a woman is on trial for fatally stabbing a toddler last year. We've been bringing you the trial of Bianca Ellis. She's accused of stabbing 3-year-old Julian Wood to death in the parking lot of a grocery store last June. Now, the boy's mother was also stabbed, but she survived her injuries. Surveillance video taken inside the grocery store shows Margot and Julian Wood passing Ellis with their grocery cart when Ellis turns around and begins following the pair. Court TV is court out there is dark today because of the holiday, but we do expect closing arguments to begin tomorrow. Court TV will have our cameras there bringing you all the live action and the latest developments on Tuesday. So keep it here on Court TV. We'll be right back.
Tonight on Closing Arguments, convicted for the murder of her former son-in-law, Donna Adelson learns her fate. Vinny is back in the studio with a closer look at today's sentencing.
Closing Arguments tonight at 8/7 Central, only on Court TV.
Donna Adelson wasn't a regular mother.
She's the matriarch mastermind.
She's just being a parent, not a killer.
Victim to Verdict with Ted Rollins. Season finale, Saturday night at 8 Eastern and Pacific.
Only on Court TV.
Plea questionnaire indicates you wish to change your plea to that of guilty to that charge. Is that your understanding?
Yes.
Do you understand that if the court accepts a guilty plea from you, you will be found guilty?
Yes.
Do you understand that a guilty plea waives all non-jurisdictional defects and defenses, including constitutional claims?
Yes.
Do you understand you're giving up your right to a trial in this matter?
Yes.
Do you understand that by entering a plea here today, you're waiving your right to remain silent and to testifying on your own behalf?
Yes.
All right, let's head back now to Wisconsin for more from the plea hearing in the figure skater crash case of Megan Schultz. Her defense attorney is speaking, and then the defendant herself will address the court. Let's listen in.
Notified that there might be a problem from the DA's office, we immediately provided all of the insurance information so that the complaining witnesses could be made whole. I would note that she has been bond compliant now for almost a year and has not only been bond compliant but also completed treatment and counseling. One of the things that struck me, knowing her and knowing her career and her history and how other people think about her, what was happening in your life? I mean, why are we here? And the only explanation, and it wasn't even an excuse, is I let alcohol get the best of me. I just recently was going through a divorce. And she'd been a couple of months removed from that divorce, and apparently she let the stresses of life get the best of her. Again, she's never made that as an excuse. It was just my prompting asking that question. It was important to know, and I think it's an explanation at least, but not an excuse. With that said, Judge, certainly she would like to keep her employment. We are asking the court to consider that. Also consider Huber and ELM would be appropriate here. She does provide for her children. I would note that we are asking for a report date in this case of October 25th, which isn't this Saturday, but would be the following Saturday. That does fit in with work scheduling as far as her being able to organize things in that regard. As relates to jail credit, Judge, she did spend 1 day in jail, so we're asking for that credit as well. Thank you.
All right, thank you. Ms. Schultz, you certainly have a right to make a statement to this court before a sentence is handed down. Is there anything you'd like to tell me?
I just want to say that I'm really sorry for this poor decision that I made. I definitely wasn't thinking clearly, and I'm really sorry for everybody in my life that it's affected, the people that I love the most. And this has really helped me actually grow as a person, and I've changed a lot in the last 11 months. And I am really grateful for that. But I'm just going to take what I've learned from this and continue to show up and be the best mom I can be for my kids, because they're the most important to me, and I love them so much. So.
Thank you. All right. There are a number of factors this court must consider at the time of sentencing, and that includes the gravity of the offense, the character of the offender, and the need to protect the public. Certainly all those factors overlap one another here today for you, ma'am, as they do for everyone who comes before this court. Also, the court is mandated to impose the least restrictive sentence necessary in order to achieve the goals of sentencing. Here, rehabilitation is an important component, as well as punishment and accountability for decisions made and protection of the community. I have read the character letters. I have read the victim statements. I do take into consideration that you finished your programming with WCS. I do find it's a first offense, but I find it particularly egregious as you had 2 children, ages 6 and 8, in the vehicle. The vehicle flipped. The vehicle hit 2 legally parked cars. You were actively drinking and driving. You had a pink water bottle filled with alcohol. The blood alcohol content was 0.218. I'm amazed no one was injured. I'm amazed no one else was hurt. I'm amazed no other charges were brought, to be quite honest with you. I think you probably recognize, and I hope you recognize, you have a drinking problem, and alcohol is probably not the best choice for you in the future. You clearly make terrible choices when you drink. And 2 of the most precious people in your life were in that vehicle. And you're supposed to protect them. And you drank and drove. All right. As to sentencing, I'll allow the motion of the state with respect to dismissing the TR. As to your sentence, it's a 12-month driver's license revocation, a 12-month IID device, a fine of $1,019.50. I'm going to authorize 100 days in the Kenosha County Jail, credit for 1 day previously served. I will grant Huber after 7 days have been served. I will grant the report date of October 25th at 8:30 a.m. You have to submit a DNA sample. Wait, this is a CT, right? Yes.
Yes.
Pay a DNA sample and submit a DNA surcharge unless previously done. Is there any money that was posted on this case previously? Let me look.
I don't see anything.
I don't see any bond posted. No money previously posted. Does your client need more than 60 days to pay that fine, Attorney Priest?
No.
60 days to pay or a civil judgment will be had. You have the right to appeal the sentence, and your attorney will go over those rights with you. Attorney Priest, anything else?
No, Judge.
State?
No, Your Honor.
Ms. Schultz, I wish you a sober good luck.
Thank you.
All All right, so there you saw the judge sentencing her 100 days in prison. Now, that's about the middle of the range from 5 days to 6 months in prison. That's about 3 months in prison. She will revoke her license for 12 months and also have that IDD device, which, again, before your car can turn on, you have to blow into it, make sure that you're not in any way intoxicated. And also, she has a fine for $1,019. That's restitution. Let's bring back in our guest, still with us, U.S. Attorney, former prosecutor Randolph Rice. Randolph, again, just want to get your reaction to the sentence by the judge. Again, sort of fell in the middle there as to what was available to the system in this circumstance.
Yeah, Michael, and she also mentioned the point you brought up earlier, which is you could have been charged with much more serious crimes here, and she probably was sort of winking and nodding to the defendant, saying, look, you got lucky by not facing those more serious charges. I think this is a reasonable sentence. My guess is defense attorney will probably file a motion asking for some reduction at some point throughout this sentence to get a little bit of that time shaved off and get her out a little bit earlier.
We'll see if that happens. There's a couple of issues here. I just want to correct something I said earlier. I said 100 days in prison. No, she'll be in a local county jail. She will not go to prison. This was a misdemeanor charge. It'll be 100 days. And she got 1 day. She had spent 1 day in jail, so she'll get credit for that. The thing, the complications here, Randolph, in terms of getting it reduced, she did refuse to answer questions at the scene. Again, that may just be a side product of the fact that she had been drinking and had a .25. But also she refused to take the test. That complicates matters, and that becomes very serious. That's kind of where the state looks at it and says, look, we're also going to revoke your license. We're also going to have you have this device on your car as well to protect the public.
Yeah, that's right. These are some of the fail-safes that the government has put in place in a lot of states, is that one is she's going to, have the sort of supervision, watching after you or watching over you after you get released. And then most importantly is that ignition interlock device, that IID that you mentioned earlier. Those are so important for protecting the public because it prevents somebody from drinking alcohol and getting behind the wheel of a vehicle and driving and ultimately hurting someone.
I wanted to ask you, as a former prosecutor, in cases like this, when you saw her delivering her statement, you get the sense that not only was she a perpetrator, but in many ways a victim as well. And again, it's by the grace of God that her children weren't hurt, but they were, in fact, her children. And one can only guess what maybe the mental things that might have, happened as a result of this. Thank God there were no physical harm. But did you ever take that into account, where the perpetrator also can be a victim in circumstances like this? Is that something you take into account? Because again, number one, she can also feel that just like them, but also she's charged with their care.
Absolutely. Any good defense attorney who comes to court before the case even goes before the judge will make these pleas to the prosecutor and say, here's the situation, here's what my client is going through. The one thing I was a little surprised about is that the defense attorney didn't lean in more to the treatment that she received since the accident up to today. That often goes a long way with prosecutors to show that somebody has addressed any type of drinking issues before they come to court.
Actually, that's a great point. I got about 30 more seconds. The judge did reference that point, that she completed a program before coming to court. And I wanted you to talk a little bit more about that and how important that was to the judge and to the court.
It's certainly important, and that's something that you really need to lean into, like I said earlier, from the defense perspective. Talk about what she learned. What did she get out of it? Oftentimes we have our clients go and do Mothers Against Drunk Driving, or they go tour a hospital where drunk driving accidents happen. And that's really important to show the judge that you see how serious your actions are.
Yeah, those programs are intense, and I know them because I know folks who have gone through them. Randolph Rice, thank you so much for joining me tonight. It was a pleasure to have you on the show, my friend. We'll see you again real soon.